now sitting. God save the United States and this honorable court. Case number 20-5076, Feng Wang and his child et al. Appellants versus Michael R. Pompeo in his official capacity as U.S. Secretary of State et al. Mr. Ramos for the appellants, Mr. Glover for the appellees.
Good morning, counsel. Mr. Ramos, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. This is Edward Ramos on behalf of the plaintiff appellants. There are a number of textual and structural reasons why the statutory framework at issue in this case does not require that the spouses and children of EB-5 investors use up the annual allotment of EB-5 visas. And I hope to discuss a few of those in my time this morning. But with the court's permission, I'd first like to focus on our APA notice and comment argument, because we think that may provide actually the easiest basis for the court to decide this case. The APA requires agencies to promulgate legislative rules through notice and comment. And the State Department here violated that requirement by adopting its policy of counting spouses and children of EB-5 investors without going through the appropriate notice and comment procedures. Now, the government claims that it did in fact promulgate this policy through notice and comment, and it points to a regulation, 22 CFR 42.32E. But if you look at the text of that regulation, Your Honors, you'll see that that regulation doesn't address the critical counting question at the heart of this case. In fact, subsection E2, which is the provision that deals with the spouses and children of investors, describes those spouses and children as receiving their status, quote, pursuant to section 203D, which is the equivalent of 1153D in the 8 USC site. And the language of that subsection is consistent with our position that spouses and children receive their status under section 1153D and not the EB-5 preference category, which is subject to the worldwide limit at 1153B5. And any question on that point is resolved if you contrast the regulation on the one hand with the Foreign Affairs Manual on the other hand. And we cite the Foreign Affairs Manual provision at page 50 of the blue brief. And that provision very clearly announces the counting policy. It says in no uncertain terms that derivatives, quote, count against the numerical limits. But the problem, of course, is that the Foreign Affairs Manual is not a regulation. It was not promulgated to the notice and comment procedures, and the public had no opportunity to provide feedback to the State Department as to whether or not the counting policy is a sensible one.
Can I ask you this question? If I read the statute to dictate that derivatives are subject to the numerical caps, then does the regulation matter? Does your argument about the procedural argument about the regulation matter?
No, Your Honor, you're right. If the court agrees with either our contention that the statute unambiguously prohibits the counting of derivatives or with the government's position, then there wouldn't be any occasion to reach the APA question because the statute would dictate the only way that the agency could do things. But we would contend at a minimum that there is ambiguity in the statute.
Before we get there, can I ask you in the regulation E2, the 42.32E2,
sure.
When it says a derivative status corresponding to the classification of the beneficiary of the petition, what does that mean to you? Does that mean that they're getting an E5 visa?
No, Your Honor. No, Your Honor. The status, in our view, refers to lawful permanent resident status, not the status, referring to the particular classification. And I think the reason that it may refer to the status corresponding to that classification is that there actually are two different forms of lawful permanent residency. You have lawful permanent resident status on the one hand, and then for EB-5 investors and certain spouses, you have additional lawful permanent residency. And so our view is that status refers to not to the particular preference category, but to the
I'm wondering about classification.
So the classification does refer to the particular subsection under either 1153 B1, B2, B3, B4.
Okay.
So
it also says if they're not otherwise entitled to an immigrant status. So it sounds like there's no other source. And if under your theory, D3 was an independent source, why would it say if you're not otherwise entitled to an immigrant status, then you'll have a derivative status corresponding to the classification of your principal, to cut out some extra words there. If you're corresponding to the principal and you don't otherwise have a status, but your theory seems to be they otherwise do have an independent status separate from the principal.
So is Your Honor referring to the regulation, the regulatory argument, or
right
to the
now
statute?
I'm talking about the regulatory argument, although a lot of the language is similar in the statute. I'm just trying to figure out how you piece these words together structurally if you aren't otherwise entitled to an immigrant status. So you have no independent, I think that language to me means, and tell me how I'm reading it wrong, I have no independent source for my status to come into or remain in the United States. And so I will have a derivative status. I have no independent one. I'll have to have a derivative status. That means it derives from somebody else. And then the regulation, and the statute does the same thing, says what I'm going to derive is the same classification, EB5, as the principal.
So, Your Honor, in our view, status refers to lawful permanent resident status or conditional lawful permanent resident status. And the point about it not having
that status, you have to have the visa. I don't know how you can separate that out from the visa. That's the visa that gives you that status.
So, Your Honor,
this is all about getting visas here. So it can't be assuming you're already post-visa and in a lawful permanent resident status.
Right. So the particular classification leads to all of these different employment-based and family-based preference categories lead to one of two statuses, either lawful permanent resident status or conditional lawful permanent resident status. And our principal contention, Your Honor, is that status more naturally refers to either of those two statuses, conditional lawful permanent residency or lawful permanent residency, rather than the particular classification.
No, I understand that part of your argument. What I'm asking is how you get there, because that's what's central to your argument is how do you get to that status if you are a family member or child, a family member. I'm just going to use family member for a shorthand. If you're a family member, how do you get to that status? And it's through obtaining a visa. And the regulation,
right.
I'm just trying to understand your regulatory argument here. The regulation says that if you're going to get that, you can't have an independent source.
So I think
if you have an independent source, you go use that. Right?
I think that's right, Your Honor.
Okay, so you must be using a derivative, as the statute says, source.
Right.
And derivative means it comes from something else. And that would be this classification, the same classification as your principal.
So but by virtue of 1153D. In other words, Section 1153D confers, says that the spouse or child is entitled to the same status and the same order of consideration. And so the question is, I think the critical question at the heart
of the regulation, it's also classification. So that you piggyback, you're piggybacking essentially. You don't have an independent source of obtaining a visa and getting the status. I don't care whether it's conditional or not for these purposes. You have to piggyback on someone else, the principal.
Right. I think that's right. But the critical question is whether or not, for the purposes of the regulatory argument, whether the visa is the person obtains their status pursuant to Section 1153D or 203D.
But if you're piggybacking, I don't understand how you're not obtaining it through the operation of EB5.
So
you don't have any. Your argument sounded like D3 was an independent source, but it's not an independent source. It's a piggybacking source. It's a derivative source. And so, why isn't the natural language, particularly use of the word classification here in this regulation, doing the work that the government says it is. It says you're piggybacking on EB-5 status. You're getting an EB-5 visa.
So, Your Honor, I think I have a few responses to that. One is that the language of the regulation is by no means clear at a minimum, because at subsection E1 and 2, E1 talks about entitlement to status, and that presumably refers to the lawful permanent residency or conditional. And then the derivative status just means that the spouse or child, they obtain that same status, but by virtue of the relationship to the EB-5 investor. But that doesn't mean that they obtain the visa under section 1153b5. And just to take a step back, if Your Honor looks at the regulatory history, there was commentary to both the proposed rule and the final rule here. And the government in the State Department, when it promulgated the rule, never recognized the key structural change that was part of the 1990 Act. And so the regulation—
when a family member fills out their visa application, the application form requires you to check a box for which type of visa you're obtaining, including one of those options is employment-based, the EB-5. And so when the spouse fills out that form and says, what kind of visa are you getting? They check a box that says EB-5. There's no D3 option on there. Is that correct?
As a matter of just factually, because the State Department takes the position that spouses and children obtain their status under the EB-5 classification, I think that's correct as a matter of fact. I think under our reading of the statute, that is not a correct way.
When they get a visa, when they actually obtain the visa, not the application form, do visas actually indicate which type of visa they are?
As a matter of just simple fact, I think the answer is yes. But as a matter of the statute, I'm not aware of any statutory provision that requires that the visa itself indicate the particular status. And our position is that under the best reading of the statutory framework, the visa is issued under the derivatives provision rather than the capped EB-5 section. And if I could point the court just to one reason, moving to the statutory argument very briefly, because I see I'm running short on time. The Congress, when it wanted to explicitly require the counting of derivatives, knew exactly how to do that. And I think if you look at the 1980 Refugee Act, you'll see that contrast very clearly. The 1980 Refugee Act borrowed language that was virtually identical to the derivatives provision at issue here. And it was in a separate section, an independent section that was not subject to the worldwide limits on refugee admissions. And yet it included an express sentence there that the spouses and children of refugees count against the limits. And that's exactly the language
that— the practice was before the 1980 Refugee Act?
For refugees?
Yes, was when they added that language, were they changing something? Were they carrying forward what they were doing before that with respect to refugees?
Your Honor, I don't know the answer to that, Your Honor. I'm sorry, I don't know the practice before 1980. That was the section that codified essentially the refugee practice, but I'm not sure what the answer to that is. I apologize. I would like to reserve—
Ramos.
Sure. Sorry, Your Honor.
If we accept the reasoning of everything you brief with regard to the reg, with regard to the statute, everything, is it possible to confine it just to EB-5?
Your Honor, we don't take a position one way or the other on that question. And
well, let me tell you why I ask. I think assume for the moment that I think there's some force to your argument, but its consequences seem huge if it's not confined to EB-5, or at least confined to EB-1 through 5. So tell me, is there a way to limit it to, at least limit it to just the employment-based category and not the family and diversity? tell me if there's a way to limit it just to EB5, or if in all candor, there's no reason to limit it. The logic of your argument goes just as much to family-based, the other EBs, and diversity as EB5. Then, then I want that answer. If that's the answer, I want that answer.
Okay, sure, Your Honor. So I think I have two responses to that. The first is I don't have a fully fleshed out theory for how it could be limited to the EB5 category, but I would point to a few features of the EB5 program that I think could provide perhaps a basis for distinguishing it. One is the job creation and the economic growth function of the EB5 program. And in other words, the EB5 program is unique in the sense that it's really was structured to try to generate jobs and generate economic growth in the United States. And it would be strange to think that Congress would have intended to dilute that job creation and economic growth potential simply by virtue of the happenstance of the number of spouses and children that happen to tag along with the investors. And there's also some language that's specific to the EB5 program, in particular the provision for removal of conditions for EB5 investors. 2 years after they enter the United States, they have to file a petition to remove conditions. And that statute distinguishes between the EB5 investor who obtains status under Section 1153b5 and the spouses and children who obtain their status by virtue of their relationship to the investor.
How does it distinguish between them?
Just the statute itself, the provision that governs removal of conditions. Excuse me, let me just pull up the provision. That on the one hand, it describes investors obtaining status, quote, under Section 1153b5. And then on the other hand, it describes their children, the spouses and children as, quote, obtaining status by virtue of being the spouse or child. But to answer, I think your honor's larger sort of floodgates question, particularly if the court were to rule on the APA ground, it would be open to the government to promulgate its counting policy through notice and comment. And the State Department has been known to quickly promulgate interim final rules. And we don't see any reason at this juncture why it couldn't do that in this case if it believed that this was the better reading of the statute. And so we would just urge, particularly if the court finds that there's ambiguity in the statute at a minimum, which we think that the briefing at least establishes that much, that the court should remand on that issue so that the department goes through those required APA notice and comment procedures. And I see I've gone far over my time.
Follow up on that, on your structural argument.
Sure.
The statutory structure.
Yes, Your Honor.
And textual argument that there's no limit, or the limits don't cross-reference D3. Would a regulation that counted family members, derivative family members against the caps be a lawful regulation?
Well, again, our principal contention, Your Honor, is that no, that the statute unambiguously prevents, but if the court were to find ambiguity in the statute, then I think we would be forced to concede that.
Your position is that it's not ambiguous in this regard. And so anyone who's in D3, which can't be confined to EB5 or even E, can't count against limits. Is that correct?
Oh, well, Your Honor, if I understand
your position,
our principal position is that the statute mandates that outcome. But if I were to, I think we have to acknowledge, for example, that the word status, if there were going to be ambiguity in the statute, I think it would turn on the word status, because the word status in 1153D is not a defined term in the INA. The INA has a definitional section, 1101, and status doesn't appear there. And so the real bone of contention here is, on the one hand, the government claims status really refers to visa classification. Our contention is that the better reading is that it refers to lawful permanent resident status or conditional lawful permanent resident status. And if the court were to find that that was in fact ambiguous, then I think we would be forced to concede that the government can resolve that ambiguity through notice and comment rulemaking, and that
But
effectively.
you don't think it's, but Mr. Roth, I mean, I get that that's the narrowest approach to resolving the case, but it's also an approach that you don't think is correct and that the government doesn't think is correct. So the only way to reach any of the notice and comment regulatory somewhat narrow consequences is to adopt an interpretation of the statute that no party in the case actually agrees with.
Well, Your Honor, the APA, I want to be clear that the APA notice and comment argument, although it's not our principal argument, it's a fallback position.
Right.
It's that if the court rejects our principal contention that the statute unambiguously requires the spouses or prohibits the government from counting spouses and children against the limits, then at a minimum, we believe there's ambiguity. And in that case, the APA notice and comment argument kicks in.
I just wanted to clarify one more thing because there was, I think I was just confused. It sounded to me from your reply brief that you agree that even if there are that these 12, I'm just going to call them 12D3 visas, the D3 dependent or derivative visas, dependent family visas.
Okay.
They are, whatever you want to call them. I do D3. I do US code
the
citation.
derivative provision. Okay, I got it.
Okay. Your structural argument, that's a separate section, that they are subject to the worldwide limits, but not to the country limits.
So that's right, Your Honor. And the per country limits, I think the section, the INA section is 202 and 1150, I think 1152.
Mm-hmm.
Yes, that is our position. And if I could clarify our position on the per country limits,
mm-hmm.
There's no question that the per country limits cover some spouses and children, because there are specific, as the government points out, there are chargeability provisions that talk about how spouses and children should be counted against the per country limits in cases where they're of different nationalities. But those spouses and children are not the spouses and children of EB-5 investors, there's certain spouses and children who are themselves defined as principal immigrants. And in particular, the special immigrant category under 1153 B4. And the major one is religious workers. And religious workers are defined at 1101 A27C. And there's a couple of other ones that are cited at page 16 of the reply brief. But they're defined to include the actual principal category is defined to include the immigrant spouse and children. And so those are the spouses and children that are covered by the per country limits. And that's made clear, I think, if you look at section, I believe it's B, subsection B of 1152, it explicitly states that the per country limits only apply to people that obtain their status under 1153 A and B. In other words, the family and the employment-based capped categories. And spouses and children of EB-5 investors fall under D.
Okay.
Thank you. I want to make sure my colleagues don't have further questions for you at this point. Mr. Ramos, we'll give you some rebuttal time.
Thank you, Your Honor.
Sure. Mr. Glover.
Good morning. Excuse me. Good morning, and may it please the court. I'm Matthew Glover, and I represent the State Department. I'd like to start with the statute's text and structure, and I confess I'm a little confused about the last answer Mr. Ramos gave to Judge Millett. I believe he said that they think that the derivative visa applicants, or I think the term Judge Millett was using was 1153D visa applicants, would be subject to the worldwide limits. And the worldwide limits are set forth in 8 USC 1151 titled Worldwide Limits. And so if he's conceding that, and I didn't understand that to be his position, but that would mean that the derivative visa applicants must take a visa from one of the limited categories. And at 1151A, and this is part of our textual and structural argument, 1151A says, exclusive of aliens described in subsection B, aliens born in a foreign state or dependent area who may be issued a visa or may otherwise acquire status as a lawful permanent resident are limited to. And then A1 is family-sponsored immigrants, A2 is employment-based immigrants, and A3 is the new category of diversity immigrants. B includes some exceptions, the most notable being immediate relatives of U.S. citizens and some special immigrants. And then 1151C sets forward the numerical limitations that the title is referring to for family-sponsored immigrants. And then D sets forward the worldwide limitation for employment-based immigrants. If he's agreeing that derivatives are subject to these worldwide limits, that would mean the 140,000 limitation in 1151D applies not just to the employment-based immigrants, but also to their derivatives. And if you look at 1153B, which sets out the categories of employment-based immigrants, it sets out for each one a percentage of this number 140. And I'll clarify, and I apologize if I'm getting too into the weeds, but 1151D has 140 plus a second number, and that second number equates mathematically to leftover family-based immigrants. So if the family-based demand for family-based immigrants does not meet the 480,000 cap in a given year, those leftover from that year are added to employment-based for the next year. It's sort of circular because if employment-based doesn't hit it, the leftover are added. My understanding is it almost never happens that there's leftover, so that's why I'm just keeping the 140 for purposes of clarity. But that 140 is then broken up among the B1 through 5 sections by percentages that equal 100%. So if derivative EB5 derivatives are taking visas from the worldwide limit in 1151, they must be taking it from one of those percentage categories. Naturally, that would be from the B5 percentage category. And I think if I can step back, this meets our textual and structural argument. Historically, since 1921, Congress has limited with a quota system the number of immigrants entering the United States. And in the INA, the Immigration Nationality Act of 1965, it set a maximum cap in 1151A of 170,000 with certain exceptions. And up through 1988, which is preceding the 1990 Act, that number actually had gone up to 270,000. But it then, in the 1965 Act, had 1153A and A1 through 6 set out, or A1 through 7 set out a number of categories and percentages. 8 was a catch-all, and then 9 was the exact same language for treatment of spouses and children accompanying or following to join. And so those people were taking visas out of the overall worldwide cap of 170 and later 270. The 1990 Act did sort of a structural overhaul and put in this provision I was speaking about in 1151A, saying immigrant visas are limited to family-sponsored, employment-based, and the new diversity category with certain exceptions. If they had intended to have an 1153D diversity or derivative visa that was not supposed to be part of the caps, you would have expected them to do one of two things in 1151, include it in 1151B in the groups that are not subject to the numerical limitations in A, or at least have in A listed a fourth category of, immigrant visas are limited to family-sponsored, employment-based, diversity, and then a D derivative, but they didn't do either of those things. They kept the same language that they had in the 1965 statute, and I think they changed the gender of one of the pronouns and added a title to it when they moved it to 1153D, or a subtitle I think would be the right term, but treatment of family members. And I think that if turning to 1153, that's another textual indication that 1153D is not intended to create an uncapped or not subject to worldwide limitation pool of visas. 1153A is titled Family-Sponsored Immigrants, specifying those immigrants that will come in under that provision. B is Employment-Based Immigrants, specifying the immigrants that are coming under that provision. And C is Diversity Immigrants. D is Treatment of Family Members. It's not derivative immigrants or some new category of immigrants. So it repeats the prior language. And I would note that we noted two bills in a footnote to our brief. Congress has multiple times in recent years taken up bills that would have added to 1151B a provision saying, 1151B, the exempted categories, it would add one stating, let me get the exact language. The exact language from the Border Security, Economic Opportunity, and Modernization Act of 2013 cited in our brief, the language would have been to add to 1151B a new category titled H, derivative beneficiaries as described in Section 203D of employment-based immigrants under Section 203B. So that would have been a specific way to have exempted only employment-based derivative immigrants from the worldwide caps. But Congress didn't enact that. That was also proposed in we call it the I-squared. I think it's also known as the Immigration Innovation Act of 2015. There was also an Immigration Innovation Act of 2017 and 2013, all of which proposed that sort of language. And in addition, stepping back to the broader structure, in the 1990 Act, Congress took the worldwide level of immigration from 270,000 immigrant visas to three categories: 480,000 family-based immigrant visas, 140,000 employment-based immigrant visas, and 55,000 diversity-based immigrant visas. So it increased the worldwide level from 270,000 to about 675,000. If it had created an uncapped category of derivative visas, using the math that the conference committee used when they were comparing the House bill, which didn't count derivatives, to the Senate bill, the conference committee's math was that the House bill had 75,000 principal employment-based immigrants, and that would equal 187,500 total. So they were using a 1.5 multiplier, that each immigrant would bring on average 1.5 derivatives. Using that math, on plaintiff's reading, in the 1990 Act, Congress took the worldwide level of immigration from 270,000 to 675,000 in these three categories, but also created an uncapped category that it expected to include 1,012,500, using that 1.5 multiplier, derivative immigrants, but it was silent about this category of 1 million, and it didn't even include that category of 1 million in the exempted 1151B.
Can I ask you about their argument about the Refugee Act and how it specifically counts family members? Do you know what the practice with refugees and family members was before 1980? Was that codifying the existing practice?
Yes, Your Honor. So I have a secondary statute that I think will help flesh this out when you were asking my colleague about that. But so refugees, sorry, if I can go back to describing the 1965 Act, Section 1153A had provisions 1 through 7 that were categories. Refugees were actually that A7 category. Mm-hmm. Then there was A8, which was a leftover, and A9 was derivatives. Mm-hmm. When the Refugee Act of 1980 was passed, it took out A7. So what was A8 in 1965 mm-hmm. became A7, and mm-hmm. what was A9, the derivative provision for 1965, mm-hmm. became A8. It took out A7 and created a new statute with a new cap. So refugees were previously taking immigrant visas under the worldwide cap of 270,000, and now they were taking them under this new separate statute and statutory structure. And so there they did choose to note that they were including them, but one of the reasons may have been because a derivative spouse or child of a refugee is not themselves meeting the definition of refugee. If I could also point out, they cite in page 12 of their reply brief some other statutes that provide for immigrant visas that aren't in 1151A. One of them precedes the 1990 Act. It's the Cuban Refugees Act. That statute allowed for Cuban refugees who reached the United States to immigrate, and specifically when it was first passed, I think in 1960 or 66, they cited in the year they cite, said that those Cubans did not count towards the A7 refugee total. And there was a time period at some point expired. And I'm sorry, I don't have printed out with me the various copies of the bills, but in 1976, Congress passed another bill before the 1980 Refugee Act saying that the Cuban refugees again would not, take out from the then A7 refugee cap that was coming out of the worldwide limit of 270. So I think in creating this new refugee structure, Congress did choose to enumerate there, but in looking at the treatment of worldwide caps and the treatment of derivatives under 1153, we think that when Congress repeated the same language and moved it to a new D section treatment of family members and didn't mean to silently create some new uncapped category of visas. And an additional indication of that in the 1990 Act is that the treatment of family members was in section 162 of the Act, which is titled conforming amendments. And so it was conforming to the prior, use of language relating to derivative spouses. If I could also highlight in response to the other statutes they point to in their reply brief, they are correct that Congress has created other statutes that allow you to get immigrant status that aren't the three family-based, et cetera, in 1151A. But when it does so, Congress includes language, and I'll start with the first one they list, the Liberian Refugee Immigration Fairness Act. It's Section 7611 of the National Defense Authorization Act of 2020. Section 7611H is titled "No Offset in Numbers of Visa Available," and then says the Secretary of State shall not be required to reduce the number of immigrant visas authorized to be issued under any provision of the Immigration and Nationality Act to offset adjustment of status of an alien who has been lawfully admitted for permanent residence pursuant to this section. And it uses similar language in the Haitian Adoptees Act that they cite, in the Indo-Chinese Parole Adjustment Act of 2000, in the Haitian Refugees and Fairness Act of 1998. And if I can highlight the Nicaraguan Adjustment and Central American Relief Act, it's known as NICARA, that they cite of 1997, it did two things. It also included this no offset in numbers, but interestingly, NICARA, and I apologize, I know the court doesn't like acronyms, but NICARA reduced the number of diversity visas available from 55,000 to 50,000 to account for these new refugees that were going to be available under that act. And it also reduced by 5,000 the number of visas available under 1153B3A Romanet 3, which I think is a skilled labor section. I'm not sure which one. But that just gets to the point that when Congress is choosing to create immigrant visa categories that aren't in 1151A, B, and C, it usually sets a specific cap and it specifically exempts them from the worldwide limits. And we just have no evidence of Congress having also.
What I'm curious about is, so you've done an argument here that's a very, elaborate exercise in statutory construction, all kinds of statutory construction principles. But, we're piecing together a lot of different statutes here, and maybe the piecing together is ultimately right for one side or the other, but it's not plain language in the way it was before the 1990 Act. And you can interpret it. I understand your arguments for your interpretation. I understand their arguments for their interpretation. But State Department's never done a regulation that says, here's what it means. We're the experts in piecing this together. Visas, that's our wheelhouse. Let's explain to you why we're doing this. So what about their argument that at a minimum here, if you're adopting this interpretation, and if it's to be deemed reasonable and get deference, you should have promulgated a regulation, and you didn't?
So, Your Honor, I would have two responses to that. The first, and I'll get to the regulation, but the first is that we think that this is clear from the statute. And as you said, I used a number of interpretive texts. We think this is the best reading of the statute. But if you were to say the statute's ambiguous, we do think 22 CFR 4232 does make this clear. And it's clear from a provision, the regulation issue, the 22 CFR. If I can walk through that briefly with you, and I'll take a quick drink if you don't mind. I know my time is expiring. I apologize. Is that all right?
Of course.
Thank you, Your Honor. So if you look at 22 CFR 4232, it's in subpart D of Title 42, Title 42, which is Foreign Relations. Part 42 is visas, documentation. Subpart D is immigrants subject to numerical limitations. So again, it's talking about those immigrants subject to the limitations in 1155A, which is the worldwide limitations. And in the 4232, employment-based preference immigrants, the opening clause, which applies to everything below it, is identical to the opening clause that was in 1153A, under the 1965 statute. Aliens subject to the worldwide level specified in 201D, except it's now 201D because 1155D sets the employment-based specific, 1151D sets the employment-based specific limitation. It used to be subject to 1151A because A had the worldwide just single cap. But so that has changed the statute citation. But aliens subject to the worldwide level specified in 201D, which is that 140 employment-based visas for employment-based immigrants in a fiscal year shall be allotted visas as indicated below. So the regulation tells us that 140,000 pool are being allotted to these people in these categories as indicated below. And so we think that's very plain that if they're counting towards the 140, and as you were discussing with my friend on the other side, and I apologize, I didn't stop at the red light to ask if I could proceed.
No, please, yeah, of course.
Okay. In the section E, fifth preference, employment creation immigrants, that's telling us that the people under here are the people who are going to be taken from the worldwide limit in 1101D for section E, which is 1153BE, employment-based immigrants, 7.1% of the overall 140,000, or as it comes to now, 9,960. The people taking up those 9,960 visas are entitlement to status and alien classifiable as a fifth preference in one, and then two, as you were discussing with my colleague, Judge Millett, entitlement to derivative status, and if not otherwise entitled to a visa. So as you were saying with him, they derive it. They're entitled to a derivative status corresponding to the classification, EB5, and the priority date of the beneficiary of the petition. So we think the regulation is very clear that this is a regulation for those subject to the worldwide cap for employment-based immigrants. And here, they place the derivatives for each section under that subsection, telling you it's subject to that percentage in 1153 of the worldwide cap.
Does the State Department have the authority to create new visa categories, or can only Congress do that?
I believe only Congress can do that, but I confess it's not something, I guess I would say, given the language of 1151A, that
not a delegation.
For at least for, if I can say for immigrant visas, I confess I didn't look at the language for non-immigrant visas. But so, the 1990 Act, when it structured these things with A, as we read A, setting forth three categories of those are where the immigrant visas come from, unless you're exempted in B. The State Department can't add to B unless it was later given statutory authority. I've seen no statutory authority, and so I'm not aware of any. I know I'm in the red light. If I could make two brief points, but if the court has heard enough, I'll also. So I wanted to make a brief point about legislative history.
I have a couple questions.
Oh, sorry.
I don't want to jump in front of.
Go ahead. Go ahead.
So,
might I make? Oh, go ahead. I apologize.
I couldn't hear the Chief Judge. Sorry.
I said I have a question too, but why don't you ask yours and then I'll.
Okay. So, tell me why this is wrong, Mr. Glover. Classification and priority refer to status in line and the type of visa. And there's no doubt that when it comes to classification and priority, textual language, that family members aren't some fourth category of visas. There's family-based, there's employment, and there's diversity. There's no fourth branch of this. So if you fall under this D, and you're going to get classified and prioritized along with a 1 or 2 or 3, because you're the family member of an EB5 visa recipient. You're treated like that EB5 visa recipient with regard to your place in line and the type of visa that you get, which goes back to Judge Millett's question. Your visa is going to say an EB5 visa. But text that tells us your place in line and your type of visa doesn't tell us anything about how we count you. And so to figure out how we count you, it was clear in the 1965 Act, because the counting flowed from your placement under a provision stating that you were subject to the INA's numerical limitations. So that's how we knew. And then Congress in 1990 changed it. They kept the text in terms of describing you, but they uncoupled it from the placement under that provision. To me, that at least strongly suggests that when it comes to counting, something changed. Because the only thing that was getting you counted before was your placement under the kind of catch-all. And now we look at the plain text without the kind of catch-all umbrella that was above it. And the plain text talks about an EB-5 qualified immigrant as someone engaging in a new commercial enterprise in which such alien has invested capital. That's 1153B5. And I think we can agree that at least some family members do not engage in a new commercial enterprise investing capital. I mean, if you're a 2-year-old child, you're not investing $1 million and creating 10 jobs. So tell me why that's wrong.
So Judge Walker, I would make a couple of points. The first is this goes to the discussion, and I tried to make this clear initially, but in changing 1151A, Congress added the exclusive of aliens described in B. So 1151A used to just set a worldwide cap exclusive of a few things, but instead they changed A to have exclusive of those in B. So B is those who are not counted in the worldwide cap. The visas.
Let me interrupt for a moment, and so you can address this before I forget to ask. B may or may not be an exhaustive list of aliens not subject to direct numerical limitations. You want it to be considered an exhaustive list, so you've got to explain to me why you think it is. You don't have to do it now, but at some point, please.
So can I start with 2 points on that? As I think I discussed or made clear in response to the statute cited at page 12 of their brief or their reply brief, when Congress did create a new new means for immigrant visas that wasn't included in 1151, it had language saying this isn't subject to the caps anywhere in the INA and all of those statutes, making clear it was doing that later with some other provision. But at the time it enacted 1153D and did the overhaul of 1151 through 1153 in the 1990 Act, the new 1990 Act 1151A has exclusive of aliens described in subsection B, aliens in a foreign state or dependent area who may be issued immigrant visas or who may otherwise require the status of an alien lawfully admitted to the United States for permanent residence are limited to. It's that limited to language that says exclusive of B, immigrant visas are limited to. And what follows.
But that's my point, Mr. Glover. I'm reading that not as referring to how we count them, but I'm reading that to referring to where we put them in line and what type of visa we give them. And if I'm wrong about that, please tell me why.
But so that tells us that you are limited to those 3 categories. And 1151A sets numerical limits of those 3 categories, the 480,000, or sorry, it's C, D, and E in 1151. It sets numerical caps for each of those categories, right? And then when you go to 1153 and you look at the caps for EB1 and EB2 and EB3 and EB4 and EB5, that adds up to 100% of the 140 employment-based visas available. So if they aren't going to be counted under their principles category, they would, I guess, be counted towards the 140, but they might just be blocked out entirely, and that wouldn't give them the same order of priority. In order to give them the same order of priority, you have to put them in line in the employment-based immigrant visa category with their principal. And so if they are subject to the worldwide limitations, but they don't have a set-aside percentage, and the percentage for all of the sections adds up to 100 for both the family-based and the employment-based, then derivatives would be getting not the same status and not the same order of priority. The order of consideration they would lose because they would only get whatever is left over. And I think, for the diversity visa applicants, it's a little more straightforward because there you just have a single limited 50,000 number. And so I think that's where 1151 working together with 1153 makes clear that you're taking from this worldwide limit of visas, and they've all been allotted. And if you look at the language in EB1 and 1153 B1 and B3, it talks about allocating and allotting visas in identical language to what was previously used under what was then 1153 A1 through 7. And so it's using that similar language that each of these provisions is allocating or allotting a visa. The A9 under the previous provision was nearly identical to what we have now. So we don't think merely eliminating the prefatory language that was in 1153A somehow takes them out of the counting, because they are still part of this new exclusive 3 types of immigrant visas in 1153.
You said something about diversity being clearer than employment, and I just didn't quite catch what you meant.
I just meant that the numbers for diversity are a little bit easier, simply because in 1153 C and D, which set out the worldwide numbers for family-based and employment-based, it has that sort of circular feedback of you add unused. Sorry, yeah. And another point, Congress just doesn't hide elephants in mouse holes. And so again, using the math that the conference committee interpreted, their reading is creating about 1,012,500 uncounted visas. And if you look at the legislative history, and I tried to find any legislative history really talking about derivatives, and all I could find was a committee report, the citation of which I can get you, but it was about the previous 5th preference, which is siblings of lawful permanent residents, that category was oversubscribed for a number of countries. And one of the examples given was, I believe, Korea and the Philippines. The principals were less than 50% of the people. And so maybe they should revise that category to only allow unmarried siblings so that you wouldn't have derivatives because the category was oversubscribed. But I was not able to find any discussion of the desire to create an uncapped category of derivatives. And Congress has been clear since then in creating new categories of immigrant visa, or new means of getting an immigrant visa. They set caps, they use caps, and they're clear when they're exempting you from the numbers in 1151. And so we just don't think that it hid this elephant or this herd of elephants in a mouse hole, because that's a substantial change from the system that had previously limited it at a total of 170 and later 270,000.
Can I ask you one follow-up question? If Judge Walker did you have?
I'm finished with my questions. Thank you. Thanks for your patience.
No, of course. I think it's related, which is there a reason that the prefatory language that the other side relies on in A to C, and that was in the 65 Act, is there a reason that it couldn't have been done in D? Or is it just that, I mean, I know your argument is that even though it's not there in D, D still naturally is subject to the caps because of all the structural arguments that you've been making. I guess my question is, is it also your submission that D just wouldn't have even made sense to carry forward prefatory language in D?
I think, so if I can make a couple of points, in the original A, the prefatory language was before all of these provisions, and because they then split out A and B and C, they replaced it in each of those. I think Congress could have taken the treatment of derivatives and placed it at the end of A and at the end of B and at the end of C, sort of repeated it in those 3 places. It didn't. I think if you put the prefatory language at the start of D, it's preference allocation for, but then you would need to, I guess, because each of them are talking about a category of immigrants in 1151A. They're repeating the language family-sponsored immigrants in 201C, which is 1151C's sort of family-sponsored numerical limitation, and B. So the D would have said, something like allocation for immigrants for family-sponsored, employment-based, and derivative, who it would have required changing. I don't know a clear way you could have repeated the identical prefatory language, because you're talking about people who are getting their visas subject to 3 different new categories. And I suppose they could have in 1151A added D, derivative immigrant visas as a new category of visas, and then put here some prefatory language saying, but you shall be limited to the cap of your principal, or some differently worded. But the prefatory language as it was included, I don't think allows, or it isn't easily converted there. And I would just reemphasize that when they were placing D, they did it in this section 162 of the 1990 Act of Conforming Amendments. It's also where they placed the order of operations. And I think I hit on this, but the order of operations really only makes sense if you're getting in line with your principal, in line towards a numbered visa system, not if you're getting an unnumbered visa, because then immediately when your principal obtains a visa, you can have the same status. So immediately, there would be no reason to continue to include that order of consideration language if you weren't meant to be taking from the sort of numbered and capped visas in 1151. Does that answer your question? Was there a second part of your question I've forgotten now?
No, that covers it.
Yeah.
Okay. My colleagues don't have any further questions. Let me make sure. Then we'll thank you, Mr. Glover, and we'll hear from Mr. Ramos for his rebuttal. Mr. Ramos will give you 3 minutes.
Thank you.
Thank you, Your Honor. The first point is on the regulation, Judge Millett's point about the regulation. And I heard my colleague mention that the structure of the regulation effectively mirrors the structure of the 1965 Act. And I think that's significant because what it means is that the State Department never grappled with the structural change of the 1990 Act. In other words, if what they were doing in the regulation is simply replicating the structure that existed before that structural change, then that's pretty conclusive evidence that they in fact didn't grapple with this new issue that the 1990 Act created. And the second point on the regulation is just to address, Judge Walker, the language you were pointing to, the status corresponding to the classification. In section 42.33E, E2, and the status, if what the regulation meant is just to say that they're accorded the same classification, it could have just said derivatives obtain the same classification, but instead they say a derivative status corresponding to the classification. And that indicates that's consistent with our reading that status refers to the lawful permanent resident status and not the particular visa classification. On the post, my colleague also mentioned the post 1990 legislative history. To begin, the courts generally accord very little weight to acts that were never passed. But more significantly, my colleague mentioned the Cuban Adjustment Act.
Okay. Sorry, go ahead on the Cuban Adjustment Act.
No, just the Cuban Adjustment Act provides a great historical example of how the State Department can misapply accounting policy for years. After the Cuban Adjustment Act was enacted in 1966, for over 8 years, the executive branch misapplied the counting policy, misapplied that statute by counting the Cubans against the worldwide limits. And it was only after 8 years that the Office of Legal Counsel and the Justice Department took a second look at this and realized, you know what, we were wrong to count them against the worldwide limits. And they stopped counting them, and there was litigation over that. And the history of that is in a case called Silva v. Bell. It's at 605 Fed 2nd 978. And that shows two things. One, that the executive branch can make mistakes in the implementation of these complex provisions. And the other is that Congress doesn't always step in to fix these problems.
Mr. Ramos, let me ask before your time's up, and I'm in part because can you just clarify on the country caps versus worldwide caps? As I understand what you said just before the end of your first argument, I think you were saying that spouses and kids count toward per country caps, but not toward worldwide caps. Is that your position?
It's close to that, Your Honor. Our position is that the spouses and children of EB-5 investors count against neither the worldwide limits or the per country limits.
Okay.
There are some categories of spouses and children, particularly of the fourth preference special immigrants, who count against the per country limits because they obtain their status under subsection 1153B. And if I said that the spouses and children do count against the worldwide limits, that was a misstatement, and I apologize. Our essential position is in fact the opposite, that they don't count against the worldwide limits.
Sorry, your reply brief, page 13, footnote 2 says derivatives are directly limited by the worldwide levels.
What we mean by that, Your Honor, and I apologize if that wasn't clear. they are indirectly limited in the sense the government characterizes our position about 1153D as it is the
Just
sort
tell
of
me what your
unlimited.
position is, please. Just, I don't care who characterizes what, just please tell me what your position is.
Sure, I'm sorry, Your Honor.
In
Our
footnote
position.
2 on page 13 of your reply brief.
Let me just pull up the brief, Your Honor, so I can be clear that I'm addressing footnote 2, Your Honor.
Page 13.
Page 13.
There you say they're subject to the worldwide limits, but they just don't reduce the number of EB5 visas. That's how I read
Right.
your footnote.
So what we mean by that, and I apologize if that's not clear, is that they're indirectly subject to the worldwide limits only in the sense that the principles are subject to the worldwide limits. That was a response
No,
to...
your sentence, I'm going to read it to you, is derivatives are directly, not indirectly, limited by the worldwide levels defined at INA 201A. So that's you're now retracting that you're saying they are not limited or they're indirectly limited.
So I think perhaps that wasn't the most artful way to express the thought, Your Honor. But I
No,
think
I'm saying this isn't artful. You said they are directly limited by the worldwide levels. Are you now saying this is not artfulness? Are you saying they are they, or are they not directly limited by the worldwide levels?
They are only in the sense that derivatives obtain their status by virtue of a principle.
What does that mean?
In other words, there is a...
They don't.
They do not expend EB5 visa numbers. They do not expend visa numbers that are allocated in Section 201A.
And I think
Both
the
203.
footnote, Mr. Ramos, your footnote 2 has two sentences I think that directly contradict each other. I'm with Judge Millett on. I don't know if she's confused, but I was confused.
I am.
I apologize, Your Honors. Our position is that the spouses and children of EB5 investors do not expend visa numbers, but they are limited in the sense that they rely on an EB5 investor. In other words, they have to be a spouse or child of an EB5 investor, and the EB5 investors are themselves limited by the worldwide limits.
So that would mean that the family members themselves are subject to no limit.
Right, that's correct, Your Honor.
Was that your position in district court?
Yes, Your Honor.
Okay, because the government's brief says that your position in district court is that they were subject to the country limits.
So the country limit provision, it's a very complex provision, and the ultimate, where we ultimately ended up on the per country limits is that the EB5 spouses and children do not count against the per country limits. That the per country
on
limit.
JA 94, this is the district court decision. I think this is the PI decision. While plaintiffs agree that EB5 derivative spouses and children are counted toward the country cap, they dispute that they are also counted toward the worldwide levels. Was the district court wrong to say that you agree that they are counted toward the country cap there?
Yes, our position did change from the preliminary injunction briefing to the position before this court. Did
you change for the district court's summary judgment decision? Or is this a new argument here?
The argument about, this is on the per country limits.
Mm-hmm.
I believe I'm sorry, Your Honor.
No, go ahead. Good.
No, I believe that we made the argument in the alternative in the district court, but I would have to go back and look at the briefing. I apologize, Your Honor.
Okay.
Further questions? Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honors.
And I just need a second. I'm trying to coordinate everything here on a smaller place than usual.
All right. Thank
See,
you.
I'm having trouble hearing you sometimes. There's like an echo or something. Justin, are you having that issue, or is it just me? Is it my problem?
I did have that issue.
I agree. Chief Judge, you started being more difficult to hear as the case progressed.
Got it. Okay, I'll try to speak directly into the microphone a little bit.
Okay. Okay. Sorry to hold everyone up. I'm not used to doing it from this tiny little desk in my house.
I think we're ready, Ann.
Thank you, Judge. Case number 20-1031 et al. The American Bottling Company doing business as Keurig Dr. Pepper petitioner versus National Labor Relations Board. Mr. Franklin for the petitioner, Mr. Side for the respondent.
Franklin, please proceed when you're ready.
Thank you, Your Honor. May it please the court. My name is Corey Franklin, and I represent petitioner cross-respondent American Bottling Company in this test of certification case. For the sake of clarity, I will refer to my client as the employer, to the respondent cross-petitioner as the NLRB or the board, and the intervener as the union. The employer manufactures, sells, and distributes beverages. This case concerns its operations in North Lake, Illinois, outside of Chicago. On June 4, 2019, the employer held a meeting with the individuals it employs as its frontline sales force, who hold the job titles account managers and sales service representatives. Sometimes these are abbreviated as AMs or SSRs, as it may be. I'll try to be specific, but if I lapse into abbreviations, I apologize in advance. In this meeting, the employer stated that it would be implementing a previously announced fundamental alteration to the manner in which it conducts its sales operations in the Chicago market. This change is called a reroute, and that this reroute would occur on July 21, 2019. Additionally, consistent with a previous description of this reroute process, the employer advised that the implementation would also result in the permanent elimination of the sales service representative or SSR position on July 21, 2019. 7 of those individuals would be offered positions as account managers, but the remaining 28 sales service representative positions were eliminated. This case arose because very shortly after this meeting, the union filed a petition for a secret ballot election. They filed this on June 14, 2019, and seeking to represent a voting unit putatively comprised of 33 account managers and 35 sales service representatives, whose positions, again, would be eliminated under the reroute. The employer, at the evidentiary hearing concerning the petition, argued that the board's shrinking unit or contracting unit doctrine required the board's regional director to dismiss the union's petition because the July 21 reroute would result in the elimination of a position held by over half of the employees at issue. At the hearing, the employer presented unrebutted evidence regarding the substantial planning and preparation already completed, customer coordination, and communication with employees already undertaken to ensure a smooth implementation of this fundamental change to its sales operations in the Chicago market. Most importantly, the uncontroverted evidence established that the employer would implement this reroute and eliminate the sales service representative position on a date certain, July 21, 2019. Notwithstanding this unrebutted evidence, the board's regional director somehow concluded that the employer failed to show definite evidence of a contracting unit and directed an election to be held on July 12, 2019 in a unit comprised of full-time and regular part-time account managers and sales service representatives. In light of the regional director's prior conclusion that the reroute implementation would not definitely occur on July 21, the employer's representative at the election notified the board agent administering that election that the reroute would indeed proceed on July 21 as designated, and the employer wanted to challenge the ballots of the SSRs who cast ballots. If the regional director believed the reroute's implementation was speculative, the employer's confirmation on the date of the election that the implementation would proceed mere days ahead should have constituted a change in circumstances justifying the application of the time-honored challenge ballot procedure. Ignoring procedure, however, the agent declared at the pre-election conference that she would not consider any ballot challenge to a ballot cast by an SSR. And consistent with her declaration, she refused to follow the challenge ballot procedure with respect to ballots cast by SSRs, despite timely objections during the course of the election by the employer's observer. After the polls closed, employees who both supported and opposed the union attended the tally of ballots conducted by the agent. The union and or its agents photographed and videotaped these proceedings in contravention of well-established board policy. When the agent noticed this conduct, she took no affirmative action. She simply said, "Oh, well," and ignored her obligation to preserve and protect the Section 7 rights of the employees who attended the tally of ballots. The employer's argument is threefold. First, the board erred in affirming the regional director's decision and direction of election. Simply stated, the board's decision does not rest on any evidence, let alone substantial evidence. The regional director, in issuing his decision and direction of election, relied on the fact that there had been a prior announcement in March of 2019 of the reroute. Due to labor relations issues involving this same union, namely the threat of a strike during the course of contract negotiations that were pending that involved the sales warehouse where the product these individuals would sell was involved, the employer pushed off the date to the next earliest available date after consultation with its customers, which was July 21.
Is that the date that was locked in?
Yes.
Okay. Isn't that some evidence? You previously had a date that was locked in, sure to happen, locked, set in stone it was happening, is the quote.
Yes.
Day 41. And you had sent out letters, payroll letters, notifications to customers, and all that paperwork, and then it didn't happen.
It did not. And I can tell you,
there was no evidence on which they could conclude that even when you said something was expected to happen on a date, it might not happen. It seems to me there certainly is some evidence. Wouldn't you agree that's at least evidence?
I would say much like...
Would you agree that that's evidence?
No, I would not.
I would agree that that's evidence of whether expected deadlines are always met in this context.
I would characterize that as a set of circumstances that the employer was forced to contend with. However, it didn't reissue any additional paperwork. It didn't go through another round of rejiggering this process. It applied the process that it communicated to its employees that it was going to proceed with. And indeed, they took it seriously enough that they filed a petition for election because they apparently were displeased with it. So they took it seriously. When the union, when the
another question, even if you were right that it was imminent and direct and imminent, I'm sorry, imminent and certain. Election can go forward as long as the even after the contraction, the proposed unit will be substantial and representative. And let me finish my question, please. And at least member McFerrin spelled out the math, did the math for me because I'm not that good at math. And I saw nowhere in your brief any dispute of the question whether there were a substantial and representative number of employees would remain even after the contraction. No dispute of that math, of that legal rule, or of that math. Am I right that you nowhere in your briefs disputed the existence of that legal rule or that math?
So I would refer the court to our reply as we address the issue of the substantial and representative complement issue. The bigger focus, though, Your Honor, is that was
where in
never.
your reply brief are you referring?
I'm sorry. I apologize as I flip through this. It may be in our principal brief. I apologize.
All right. Well, maybe you can just tell us on rebuttal. I don't want to waste your time
Sure.
right now.
Ultimately, however, Your Honor, Member McFerrin's footnote is the first time that's ever raised by anyone. And it was never raised by the regional director. The regional director had a laser-like focus on whether there was evidence of a direct and imminent contraction of the unit. He ignored any evidence that we proffered. It was unrebutted, and chose instead to go on his own subjective impression of what the unrebutted evidence and testimony at the hearing meant. And instead of
you help me understand how this test works. You have the burden here.
Correct.
And even assuming you were right on showing imminent and certain, is it your burden to show also that after the contraction, there would not be a substantial and representative contingent of employees remaining?
There are three factors that the board looks to determine whether there's sufficient evidence of unit contraction to warrant dismissing the petition for an election.
Mm-hmm.
The time period between the representation, the RC hearing on the petition and the expected contraction, the steps taken by the employer to effectuate the change, and whether the employees have been notified.
And that all goes to imminent and certain. So what I'm saying is assume, that's what you focused your argument on here. I got that. But it seems to me to end or terminate or prevent a union election, there has to be more than just imminent and certain contraction. There also has to be, because the election will still go forward even with that imminent and certain contraction if a substantial and representative contingent of employees remains. And so what I'm asking you is, do you have to show both of those things to show that the election should not have gone forward? That's not our belief. One, and two, even whose
assuming
burden is it? So is it the general counsel's burden to come back and show?
I think it's the burden of the union at the RC hearing to demonstrate that there's a substantial and representative complement of employees that remains.
Okay. Is there case law that says, is there board case law or case law in this court, if I've missed it, that says who has the burden of showing, if the person trying to stop the election, do they have the burden of showing both prongs of that test, or whether it's like the burden shifts to the union once certain and imminent is shown? I'm just trying to figure out that you have an obvious reaction and you're much more expert in this area than I am, so I'm just trying to understand where that comes from.
I don't have that before me. Even assuming for purposes of argument that the employer were to hold that burden, the fact remains that the unrebutted facts in the record at the representation hearing support the proposition that over half of the putative unit would be eliminated, and an entire job classification of only 2 job classifications in that petition for unit would be eliminated and
well, seven, if I've got the number right, I think it was 7.
That's right.
The individuals were going to be converted to people that were still within the unit.
Correct.
Okay.
Well, why isn't that enough? Can you hear me? I'm sorry, I'm making sure that I'm audible.
I hear you, Your Honor.
Yeah, if you agree on the 7, which that is what was reflected in the materials, then why isn't that enough? Because I thought the math worked out so that would be enough.
So when you look at the count 62 ballots were cast. Because the challenge procedure was not employed, we had none of the ballots were segregated by voter. So we don't know who voted. Had the challenge process been followed, we would know whether a substantial and representative complement voted or whether or not the process played out in such a way as to be actually representative of the unit.
I thought the whole point of the way the math worked out was that it didn't matter, because we know from just the existence of the 7 that even if you allocate everybody into one category, it's still going to work out so that substantial and representative is met.
From the employer's position, again, that was never the argument raised by the board, and it's not the ruling under review. The ruling under review that was affirmed by the board, and only you have one footnote by Member McFerrin that raises this issue. The sole and exclusive basis for the board's ruling is the issue of definiteness.
Can I just ask you then, that just on the numbers, because I thought the way the numbers worked out just dealt with this. Do you have an answer actually on the math that says that because there's 7 who are still, even though the position is eliminated, they're still going to remain within the unit, but that's not enough. If you don't have an answer, that's fine, but I want to make sure that I understand whether there is actually a math answer.
We don't view this, our argument or our case, as a function of the math problem. And I don't.
Does that mean you don't dispute the math?
No, I'm saying that the math wasn't the basis for the ruling. And
I'm just asking you, I think we're just asking you this factual question
Sure.
here from the record. Remember, McFerrin did the math. I didn't see anything where you disputed it, and that could be I missed it. I'm sorry, Chief Judge Srinivasan, I didn't mean to step on your question. I'm just trying, at least I think you're asking, I hope you're asking the same question. I just want to know, do you dispute the math?
I don't dispute that there are a grand total of 40 bargaining unit employees once an appropriate unit has been defined. But allowing 68 employees to be eligible to vote for a 40 employee unit makes no sense in this context, and allows individuals who have no reasonable expectation whatsoever of being employed in the unit determine the representational status of the remaining employees.
My colleagues don't have any further questions for you at this point. Maybe we'll hear from the board. Mr. Seid.
Good morning, Your Honor. May it please the court, David Seid for the Labor Board. The board acted in its broad discretion by declining to dismiss the election petition because it reasonably found at the time of the pre-election hearing, the company failed to carry its burden of establishing that it would eliminate the SSR position during the week of July 21st, 2019. Rather, for essentially 4 reasons, the board found that target date is aspirational. First, the board looked at the history, and the history doesn't just have one occasion where the company failed to meet a target date, but 3 occasions. And this was a process that started all the way back in November of 2017. And during that time period, the company failed to carry out its plans, notwithstanding it indicating that at various points it was immersed in its plans, that it finalized its plans. And it's no surprise because the company itself acknowledged both in its brief and at the hearing that this was a very arduous and difficult process that involved a lot of planning. Second, the board relied on the email that a vice president sent on June 4th, 2019. In that very email, the vice president referred to the week of July 21st as merely a target date. And it also referenced about coordinating the elimination of the SSR position with another change that had to take place regarding the bulk route drivers. And the email expressed concern that both of those had to occur at the same time, or otherwise it wouldn't be fair to either the employees or the customers that would be affected by the changes. Yet, as the board noted in the regional director's decision, 3 weeks later, when the pre-election petition hearing was being held, there was no update regarding that June 4th email. What was going on? There was no reply from other executives. There was no indication of what's going on with either the SSR change or the change that's supposed to be taking place with the bulk delivery drivers. And it's the company that controls the decision-making process. And it certainly had ample opportunity at the pre-election hearing to do more than introduce simply one email from June 4th to indicate what exactly was going on and when it was happening. Third, the board reasonably relied on the fact that less notification was provided with respect to the week of July 21st when compared to other time periods that had been announced by the company. For example, there was no evidence that letters were sent to employees, nor for that matter was there even evidence that the customers had been notified. And then finally, the board also considered that there was no evidence that the master data could be completed. And I would like to touch on this because the company in its brief makes reference referring to testimony from pages 84 and 85 of the appendix that area manager Troutman had indicated that the master data was complete even as of April 1st, and that it was simply basically a matter of touching the button and it would all be done on July 21st. However, earlier in his testimony at pages 73 and 74 of the appendix, he'd indicated that one of the reasons why the change didn't take place on April 1st and couldn't even take place by May 1st was that even if certain issues got resolved regarding some bargaining issues with some other represented employees, that the company would be unable to complete the master data switch, not only not being able to do it by April 1st, but also not being able to do it even by May 1st. And so it's within the context of basically these four factors that the board was fully warranted to find that at the time of the representation hearing, the company failed to carry its burden that would eliminate the SSR position during the targeted week of July 21st, 2019. One other point raised by the company with respect to its post-election objections, it's well settled that with respect to post-election objections, that an employer cannot re-litigate the eligibility of voters to vote outside of being able to show that there were changed circumstances. And the only thing that was offered in a attached affidavit or a statement was simply that, well, it's going to happen on July 21st. Again, we're now 9 days away from the target date of this happening, and yet the company didn't produce any records, any emails, anything.
Can I interrupt and ask, is your position that it wasn't clear that the reroute would ever happen, or is your position just it wasn't clear that the reroute would happen on July 21st?
Your Honor, the board's position is that the company failed to carry its burden at the time of the pre-election hearing that it would take place during the week of July 21st. The board is not disputing, right? The board is, I'm sorry, Your Honor, the board is not disputing that as early as late 2017, it announced an intent to want to do this. So whether it takes
at the time the decision was, at the time that the ruling was made, the thought was the company has not proven this will happen on July 21st. Had the company proven that it would happen within, let's say, 6 months of July 21st? I lost your audio. I don't know if you lost mine.
For how the board would Your Honor, for a second, but I think I did hear your question. Are you still able to hear me?
Yes.
Okay. So the board hasn't definitively stated a time frame for when it would consider an imminent contraction. Generally, in a number of the cases, the board has made a determination within about 1 to 4 months of the time of a pre-election hearing. So
that would be imminent. That would be imminent enough.
That, in general, has
did
considered
the board,
that
in this case, did the board conclude that the company had not demonstrated that the reroute would happen within 4 months?
Your Honor, the board didn't need to specifically state that because of the company's position before the board was not that it would happen sometime, say, between July and September or October, but it was specifically that it would happen the week of July 21st. So that's what the board is considering. The company wanted to make an argument that, well, we're aiming for July 21st, but here are 3 different reasons why it may not happen until September 1st, but here's why that would be the drop dead date, so to speak. It could have done so, and the board would have obviously evaluated the facts.
So I get that it's the company's burden to show that it's imminent, but if the company has produced evidence to convince the board that it's imminent being defined as within 4 months, then isn't that the question the board has to answer, or the regional director has to answer?
Your Honor, given that there's been delays dating back to early 2018, the board is considering the specific claims that were raised by the employer. The employer, in fact, the employer criticizes the board for relying on the July 21st date. That's a date that the company kept saying it was going to happen. The board actually, if going back to the regional director's decision, actually considered the week of July 21st, which was actually the target week that was set forth in the vice president's letter on June 4th. So the board doesn't directly have to consider that it might have happened at a later week or even a month later. It needs to consider what is the argument being raised by the employer at the pre-election hearing.
And what's your response to, or remind me a response to this tension between what the board did here and what the regional director did in the unfair labor case, where the regional director found as a finding of fact that the company had made the decision to implement the reroute before the date of the union election.
Sure. Putting aside that it's an unrelated issue, that it's also a decision by the general counsel whether or not to issue a complaint, which is not a board decision, but also the question, the board isn't disputing that there is a decision made going all the way back to 2017, that there was a decision made at some point in time to eliminate the SSR position. But there's a difference between saying that there's a desire or an intent at some point in time to eliminate the SSR position, or that decision was made before the election was held, and being able to carry a burden at the pre-election hearing of setting forth a specific time frame that is definite and imminent for that change to take place.
Okay.
Is it the employer's burden, or is it otherwise, to show not just that contraction is certain and imminent, but that it will be a material contraction in that there will no longer be a substantial and representative unit? Or if they show imminent and certain contraction, does the burden shift to the union or the general counsel to show that a substantial and representative contingent will remain?
Your Honor, I see that my time is up. I presume I can answer the question. It wouldn't be the general counsel's burden because at a pre-election hearing, the two parties...
It would not, I'm sorry.
It would not be the general counsel's burden because at a pre-election hearing, the two parties are the union and the employer. Mm-hmm. I'm not aware in any of the cases where the board has explained the representative complement principle. It has specifically discussed whether it is on the burden of the employer or the union, but very clearly, it is the second part of the test that even if an employer does show that there is a definitive and imminent date to make a change, that nonetheless a representative complement wouldn't remain. And in here, there is no dispute, as Member McFerrin said.
It's like if they came and said there's a certain and imminent contraction of one employee, and they had the best evidence in the world of certain and imminent, no one would think they had done anything to show that the election couldn't go forward, assuming the one person wasn't going to change the
That's correct.
But I'm not so sure about, that's one way of thinking about it, but that may not be the right way, and it's the board's test. So that's what I'm trying to understand.
Right. Well, the board's test, Your Honor, has generally been that if at least 50% of the employees would remain, and at least half of the classifications would remain. And in here, as Member McFerrin did the math, there would be at least 58% of the petitioned for unit would remain, because you have not only the 33 account managers, but you have admittedly 7 of the SSRs that would transfer over into account manager positions. So that would be 30 out of the 68 employees in the petition for unit, or 58%. So under the board's standard, in cases where it has applied this principle, it is over 50%, as Member McFerrin stated.
But is it 50% is the threshold? I thought it was, maybe I'm misremembering. It was 50% of the classifications, but I thought it was a different number on, was it 30% on the?
I apologize, Your Honor. I think I might have misspoken. I think it may have been, and it may be 30, it was 50% of the classifications, and it may be 30% of the employees. I think that's correct, Your Honor. I apologize.
Okay, colleagues have no further questions. The board will hear from, thank you, Mr. Saib. Mr. Franklin, 2 minutes for your rebuttal.
Thank you. A couple of points need to be touched on. One, this notion of the fact that the board, on the one hand, wants to concede that it could have been within a week, and then in the decision direction of election focuses on a date certain. We provided evidence of a date certain, And they decided that it wasn't going to be enough evidence, even though it was totally unrebutted. And ultimately, the reroute did proceed, notwithstanding the emails that they believed that we should be using to run our business were not present. The unsupported argument to the contrary, the employer did not repeatedly delay the implementation of the reroute. It had planning. The only announced reroute to employees was one that had a date certain, was the April reroute. And that April reroute was postponed because of the potential for a labor strike. And
does that matter to the certain and imminent test? What the cause is? Does it have to be an employer-based cause?
No,
it doesn't.
I wouldn't. But it's matters outside of our control. And that
again, does that matter for purposes of? Can the board say, "I believe you that was your intent," or a hypothetical, another case, employer, I believe that was your intent. There's no question that was your intent, but the last 5 times in a hypothetical case, some external factor kept it from happening. It just seems to be jinxed. It never happens.
That I presume it can take that position, but on the facts, what occurred here was that all of the work, and contrary to my counterparts' representations otherwise, all of the work was done. The only thing that needed to happen was for the date to pass. And yes, you couldn't do it the next, if you told me that we were going to run a reroute tomorrow, I couldn't push a button and make it happen tomorrow. But when you have a date certain and a date certain picked, and all of the work has been done, and as it was done, as the record shows, by June 25th, the parties were in a position, or excuse me, the employer was in a position to execute. April 1 was the only date that was specifically given, hard date certain, that was given to employees prior to this intervening incident that required us to push it to July 21. And the July 21 date was picked after consultation with customers and consultation with the rest of the business to make sure that could be effectuated properly, notwithstanding any other issues. And that was indeed the date that it was effectuated. Again, the issue of the substantial and representative complement, again, that was never the basis for the board's decision in this case. And the focus, although esoterically interesting as a matter of law, is not the decision under review. The decision under review is whether the employer established a definite date for the reroute, because that's what the regional director premised his decision on. And aside from a stray footnote by a member in the minority on the National Labor Relations Board, that's not what they.
She wasn't in the minority. She agreed. It was unanimous.
The Democrat-Republican split. I apologize. Ultimately, that was not the basis for the decision under review. So, to the extent that we're compelled to answer to the arguments raised underlying by the board, the argument that they raised was that the date certain wasn't established, notwithstanding the fact that the unrebutted evidence established that not just July, not just June, not just sometime this spring, a specific date certain was identified and testified to over and over and over again without any contradiction by
I think we have
Vice President.
On that point. I think we have your argument on that point. Let me just make sure my colleagues don't have any further questions. If they don't, thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honor.
Case number 20-5030, Peggy Wilson, appellant, versus Jadif Wolf in his official capacity as Acting Secretary of U.S. Department of Homeland Security. Mr. Ward for the appellant, Mr. Serino for the appellee.
Morning, counsel. Mr. Ward, please proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Larry Ward. I'm representing Peggy Wilson, who is an employee at the Department of Homeland Security. This is a Title VII case involving Mrs. Wilson, who at the time, at the age of 59 years old, applied for a position of Supervisory Financial Management Specialist at the Department of Homeland Security. She had served as a bank card manager also at the Department of Homeland Security 2 years prior to the time that she had applied. And she had been bank card manager for 6 years between 2006 up until 2012, in which time she received outstanding performance evaluations from 4 different supervisors. After returning in 2014, she applied for the job, which was 1 notch above the job that she had previously held. During the selection process, her resume was not forwarded to the next level, which would have been a full panel, which consisted of 3 persons, 2 of whom were her previous direct supervisors, and 1 of whom was another.
Mr. Ward, can I ask some questions about representations in the brief that you filed, the statement you just made about her resume not being reviewed by the panel is really the first one. You say throughout your brief, including on page 11, that Ms. Burris did not review the resumes. Where's your support for that in the record?
Well, support in the record is her affidavit. In the appendix, I've included her entire affidavit.
Can you remind me what page of the appendix her affidavit is?
Yes. I believe it's pages 132. I'm sorry, Donna. Give me just 1 second. Oops. I'm sorry, Donna, I don't have that appendix before me at this particular time.
Is it Christine Burris you're talking about?
Yes.
That's JA 237 is where it starts, her
Thank you,
declaration.
If you could bear with me then, Mr. Ward, and thanks to Judge Millett, could you tell me, check out that declaration that starts at JA 237. I don't read it to say one way or another whether Ms. Burris reviewed the resumes. Can you tell me where you think that it does say that she did not review the resumes?
Yeah, there was one particular statement, I believe it was number 17, where she says specifically that she only participated in one aspect of the entire selection process.
She says, I was not privy to the process of the actual selection of Mr. Taylor. I don't view that as her saying that she didn't review the resumes. Do you view that as her saying expressly that she did not review the resumes?
I reviewed the entire affidavit, and in reviewing that entire affidavit, in summarizing what her affidavit says cumulatively, I read that to say that she did not participate.
And when Ms. Morgan Loudon on JA 192 and 193 expressly says that Ms. Burris did review the resumes,
well, that's
why doesn't that disprove your point?
Well, it doesn't prove the point, because they're simply saying that Mrs. Morgan Loudon stated that Mrs. Burris was present at the meetings, but when you read Morgan Loudon's testimony I believe at the 3rd page of her testimony, she indicated that she wasn't sure.
Let me be specific, Mr. Ward. On page 22 of the deposition on JA 192, she's asked, who aside from yourself, who else helped you review these 47 individuals? And she says Christine Burris, as well as Jeff Bobich. And then also on page 26, she's asked, so are you certain that Christine Burris would have been included in the process trying to determine which of the 47 individuals should be selected? And she says yes. So when you say Ms. Burris didn't review the resumes, you're contradicting the testimony of Ms. Morgan Loudon, correct?
Absolutely.
You are, okay. So you also say the regulation required that Ms. Burris participate in writing questions. You say that on page 31 of your brief. Can you tell me where in the regulation it says that she was required to participate in writing the questions?
Well, I guess the point regarding Mrs. Burrows is that
it's really a question about the regulation.
Mr.
Ward, Mr. Ward, it's really a question about the regulation. Can you tell me where in the regulation it says that Ms. Burris was required to participate in writing questions?
No, I'm reading the regulations broadly. I'm reading them from the standpoint that if you were a manager working at a large corporation or a large agency, and you're familiar with regulations 335, as well as the whole body of Supreme Court precedent, which requires that individuals should be treated equally. And also,
but Mr. Ward, I'm asking specifically what text in the regulation requires participation of a minority panel member when writing interview questions. It may be great policy. I'm not disagreeing with that. I'm just saying where specifically in the regulation does it say what you say the regulation says?
Okay, there is a Department of Homeland Security regulation, which is not in the appendix, and it's regulation number 0480.1, which is dated March 1st, 2003. And essentially what it says is that the Department of Homeland Security should adhere to all laws and regulations that provide equal opportunity for all Americans, regardless of race, color, religion, sex, national origin, age, or handicap.
So you're saying that does not specifically require the participation of minority panel member in writing the questions. It makes a general statement that you're interpreting to mean that.
Absolutely.
Okay. On page 12 of your brief, you say the regulation required the panel to keep their interview notes. Can you tell me where in the regulation the panel was required to keep contemporaneous notes?
I believe it's also in regulation 335. And I don't, let's see, I could point that out in my.
That's if you gave me the number, I'm happy to go look at it after oral argument. Three more, if I may. You say this is on page 10 of your brief, as well as page 11, and then again on 26 and 38, and then 4 times in your reply. You say Ms. Morgan Loudon, quote, withheld Wilson's resume. Where in the record is that?
I'm sorry, could you repeat that, Your Honor?
Where you say that Ms. Morgan Loudon withheld Wilson's resume. Where in the record does it say Ms. Morgan Loudon withheld Wilson's resume?
I think that that was an omission in their answer, and also in, I can't point to specific, see. Oh, it was in Morgan Lowen's deposition excerpt where she indicated that she admitted that she had withheld the resume for the reasons that she did not feel as if it represented the type of leadership and projects that she and Mr. Bobbitt sought.
So you don't mean that she withheld the resume from Ms. Burris or withdrew the resume from those that would be reviewed by others. You just mean she didn't think that the resume was good enough to receive an interview. Am I interpreting you correctly?
That's correct. By the full panel, which would have included Mrs. Burris.
Right. And then on page 31 of your brief, as well as 5 other places, you say the district court erred when it found the selectee significantly better qualified for the job than the appellant. The district court actually said that the burden is on you, and you cannot, this is from JA 310, Wilson cannot establish that she was significantly better qualified for the job than Taylor. Would you agree that you're flipping the burden there?
I believe that the burden is upon, I'm sorry, could you repeat that question, Your Honor?
You say that in your brief that the district court erred when it found that the selectee, who in this case was Mr. Taylor, was significantly better qualified for the job than Ms. Wilson.
Yes.
But the district court actually simply found that you did not meet your burden to establish that Ms. Wilson was significantly better qualified than Mr. Taylor.
Which brings me to the point, which is the whole issue here is that we believe that the district court was clearly erroneous.
So you think the district court got the standard wrong?
We think that the district court was clearly erroneous in its fact finding because it
That's not, Mr. Ward, that's not my question. Do you think the district court got the standard wrong when it said Wilson failed to establish, the standard being on Wilson, that she was significantly better qualified for the job than Taylor? I know you don't agree with the fact finding.
Yeah,
I'm not expecting you to. I'm just asking, do you think the district court got the legal standard wrong when the district court said it was your job to establish that Wilson was significantly better qualified than Taylor?
No, I agree with that.
Okay, this is my last question on your brief. You say on page 12 and 14, and then again in your reply, that Mr. Taylor had no supervisory experience, but he actually led a team of 9 in developing the methodology of allowing 15 reporting components to allocate major program costs. I guess the reason, and then this is my last question, whether we agree with you on whether the district court erred or not, some courts have said that grossly inaccurate statements in an appellate brief subject an attorney to Rule 38 sanctions. And I wonder why you don't think that the 6 statements that I've gone through are not grossly inaccurate.
I don't think that they're grossly inaccurate because I think if, for example, you take the issue of whether Mrs. Burroughs' affidavit shows that she did not have an opportunity to participate, I think that it is accurate. And I think that there, at the very least, there's a dispute of fact there. Because she said the defendant is trying to say that she did not participate, and we're saying the defendant is trying to say that she participated, and we're saying that she did not. And I think that affidavit shows enough in the context of the Morgan Logan deposition, in which she states that she was not sure whether Mrs. Burroughs participated or not. I think that's enough to create a factual dispute. However, I really think that she did not participate, and that's my belief. And with regard to the issue of who has the burden of the qualifications, I think you set forth the standard under ACA versus Washington Hospital Center, under McDonnell Douglas versus Green, under Foreign Corps versus Waters, under Teamsters versus US. And the idea is that the plaintiff does have the burden of showing that they are qualified, but how can you prove that burden if the judge is withholding facts? My client worked in an outstanding position, doing outstanding work for 6 years, and I specified that.
There again, Mr. Ward, didn't the IG report say that things were not going exactly swimmingly when it came to the bank card programs at the Department of Homeland Security?
I'm sorry, could you repeat that?
Didn't the Office of Inspector General issue a report saying that the performance of the bank card offices in the Department of Homeland Security had problems, significant problems?
The issue is whether they were related to my client or not. And I think I set forth in my brief very specifically that it did not have anything whatsoever to do with my client.
Did the government come forward with any evidence that any of those problems were related to matters within Ms. Wilson's control?
Well, my client, I'm sorry, could you repeat that, Your Honor?
Did the government come forward with any evidence that those Inspector General problems were things that were within Peggy Wilson's control?
No, they did not, Your Honor. And I had specified in my brief that
Didn't she actually lead a response to part of the Inspector General report to fix the problem?
No, they did not, Your Honor.
She didn't. I thought she led a response. Maybe it was a different.
I'm sorry. Yes,
I thought she did lead a response to that.
I'm sorry. Yes, she did. Yes, she responded. She indicated that she was in a policy part of the Department of Homeland Security, and the issue that arose there was related to a lower level practical problem. And ultimately, she was asked to assist them in resolving that practical problem. And as a result of helping them resolve that practical problem, she received the highest performance evaluation from her supervisor, who also supervised the selectee, Robert Taylor, who got the job. And his opinion, as I pointed out in my brief, was that he thought she was significantly better qualified for the position than Mr. Taylor was. And he would have known because he filled the position, he would have known because Mr. Taylor filled the position that he had after he left the department.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Ward. And hearing none, why don't we hear from the government? Mr. Serena, we'll give you some rebuttal time, Mr. Ward.
Thank you.
Good morning, Your Honors, and may it please the court. My name is Paul Sereno for the defendant in this case.
Mr. Sereno, can I start where Mr. Ward left off? Did the Boyd affidavit say that Boyd was taking a position on who was significantly better qualified?
No, Your Honor, that's not our reading of the affidavit. Mr. Boyd supervised both of the Ms. Wilson and Taylor in 2011, which is 3 years before the job announcement in this case, and didn't speak to who was substantially more qualified for the position at issue, and he didn't even know.
Well, given his very surprise to learn about the hiring process, I understand that's your reading of his testimony. My question to you is simpler: would it be irrational for a jury to look at that and infer that Mr. Boyd concluded that Wilson was more qualified?
It would, Your Honor.
It would be irrational for a jury to conclude that?
Let me say it this way. I don't think it's a reasonable inference.
That's the same thing. So it's irrational for a jury to read his very surprise to learn that Taylor got the position given his experience working with both of them and the accolades he showered on Ms. Wilson, his lengthy experience with her, and Mr. Taylor's lack of supervisor experience. It would be irrational for a jury
to conclude that Wilson was substantially more qualified for the position at issue in this case, which he didn't know about.
And his former position. That
right,
would be irrational for the jury to conclude too.
Well, there was a new director that was the decision maker to select the.
And I'm not disputing your reading of the evidence, to be clear, and all your arguments. Yeah. They're not mutually exclusive at all. It's just if we put all this stuff in front of the jury, and just on this narrow part, there's other disputes in this case, or potential disputes in this case. And Mr. Boyd says, look, I worked with both of them. I worked with her extensively. Here's all the things we did, all the accolades. I couldn't go anywhere without her because she was the key person on this in the department. I was very surprised. It would be irrational. And I don't want to use the significant qualifier. I'm following our case, Hamilton versus Geithner. So I just want to know whether it would be irrational for a jury to factor, let's just say factor that in. Could that help them infer that he thought at least she was more qualified for the job?
Your Honor, I think the most that you can infer from the Boyd affidavit is that he believed, based on his experience, that Wilson was a better employee than Taylor.
Was more qualified.
As of 2011.
Okay, that's fine. That's fine.
There were, Taylor had 3 additional years of experience that factored into his selection for this position in 2014.
I thought there was a 2-year gap. Am I wrong? Is there a 3-year gap? Are you
I
including the
believe-
hiring process time?
I believe his affidavit speaks to the 2011 time period, and the job announcement was 2014.
Okay, thanks.
Well, Your Honor, that's the issue, is whether there's admissible evidence in the record from which a reasonable jury could conclude that the non-selection of Wilson was due to unlawful discrimination. And our view is that there is no such evidence in the record, and that the court
No
properly.
evidence or insufficient evidence?
I think I'll say insufficient, Your Honor, that from
Okay.
which a reasonable jury could make that conclusion.
And I'm
It's
sorry, did
not
I
there.
step on your questions, Mr. Judge Walker? I'm sorry.
No, not at all.
All right. So if you look at the posting for the job, where they wanted specialized experience, including overseeing the bank card program and supervising staff, and Wilson were to introduce admissible evidence, which she seems to have, of 6 years of experience managing the bank card program and directly supervising 3 individuals and indirectly supervising 66 others. And then the jury also heard that Mr. Taylor had, as he said repeatedly in his testimony, no bank card experience and very little supervisory experience. But to be sure, you would have your evidence of the other skills that he had. Could a jury factor, a rational jury factor, how closely Ms. Wilson's resume mapped onto the actual job description? Could they factor that into a decision about whether there was pretext or discrimination, or would it be irrational to do that?
I think the candidate's qualifications are is a basis from which the jury could infer pretext in the event that the one candidate was substantially more qualified than the other.
What evidence did they have? What evidence? I think one of the things that was relied on here was that Mr. Is it Bobbage or Bobbage? And Morgan Loden talked about the evolution of the position. Other than them referencing that in terms that then described Mr. Taylor's after the fact, describing Mr. Taylor's qualifications, was there external evidence that the position had evolved in so significantly in a 2-year period?
I think that Director Bobbage was relatively new to the position that he had to fill here. The context of the announcement was the need for stronger internal controls and risk prevention, which required a broad set of skills that was different from what the position had demanded in the past.
Wilson had, if evidence were introduced that Wilson had implemented internal control checklists for the bank card program and had worked with 66 program coordinators to ensure internal controls, and then the argument was that the position had evolved to emphasize internal controls, could a rational jury factor that evidence in determining whether this evolution was the basis for was a genuine basis for picking Mr. Taylor over Ms. Wilson? Or not even letting Ms. Wilson out of the starting gate, honestly. She wasn't even allowed to interview.
I don't see how. I just don't see how that.
I'm just asking an error question, not who wins. Is there something irrational about a jury's reliance on that kind of those inferences and comparisons of evidence? They might be wrong, and you might be able to disprove it, but is there something irrational as a matter of law about allowing a jury to weigh those things?
I think those are facts in the record that that
The juries would normally weigh.
can take into account.
Okay.
However, in this case, I don't see, I wouldn't see any inference from those facts that could give rise to a
Well, then
pretext.
I'm going to add all this. We can all add it all up together. We don't have to win everything on one of these, right? Wilson doesn't have to do that. So Morgan, Loden, and Bobich both said that they were looking for an ability to lead projects and people and to lead change. And Taylor, I think, might have been 3 times, said he hadn't had supervisory roles. Maybe at the end he'd finally had a little one.
I think
A jury could consider that. You wouldn't consider it contrary to law to allow a jury to rely on evidence like that as part of other things in deciding whether to infer discrimination or not, or pretext.
Well, I think what Taylor was referencing was that he wasn't a supervisor in the sense of being in a position to discipline people, hire, fire people, and I believe the agency was considered supervisory experience to include supervising a project or leading a team.
Oh, I thought they said lead people and projects. Am I wrong about that?
Well,
Did they say they only wanted leading projects?
Leading a team to
Okay,
accomplish a
that's
project,
leading people then. That's leading people.
and he led a 9-person team. So that I think from the agency's point of view, that would qualify as supervisory experience.
Mm-hmm. Okay. There were some questions from Judge Walker about Morgan Loden's testimony on her deposition, sorry, not testimony, on whether Ms. Burris had been consulted at the interview stage. But Morgan Loden said they didn't all sit together. They talked one at a time with Mr. Bobich, correct? I'm on JA 192.
That was her testimony.
Right, and so she didn't really know whether he talked to Ms. Burris or not. She just said he's extremely thorough and detailed in knowing process. So that's what she was relying on.
She was not present for a conversation between Bobich and Burris regarding.
And she hadn't even really asked Bobich. There's nothing here to indicate she'd asked Bobich about whether Ms. Burris was involved.
She didn't inquire about their discussions regarding the selection, but there was no dispute.
Would it even be admissible as evidence then?
On what point? I mean,
she's speculating that she thinks Mr. Bobich would have talked with Ms. Burris, but she doesn't know.
Well, but there's no dispute that Ms. Burris reviewed the 47 resumes, including Wilson's.
Well, she says it's kind of confusing what she did or what she thought her role was, because Judge Walker's pointed out that that she says she certainly wasn't involved in the final interview stage, Mr. Taylor, but she also says a couple times, I have no basis for comparison when asked to compare the two of them. So that's what's kind of confusing. And it's, it's a declaration. It's not a deposition where questions are asked. So it's kind of confusing.
Well,
the inferences are that would come from that.
I don't see the confusion, Your Honor.
I have no basis for comparison.
Right, because she can't compare Bobich versus Taylor, but she reviewed the 47 resumes.
Wait, sorry, you mean Wilson versus Taylor? Well, then she would have a basis for comparison. If she had reviewed the resumes and she was aware of this evolution in the position, she'd have some basis. She wouldn't be able to evaluate their oral skills in an interview, but she would have a basis for comparing their whether they were qualified, right?
Based on the resumes that she reviewed.
Would she have been privy to this evolution in the position too?
I don't think that that's covered specifically in the record, but it appears that Mr. Bobich explained to both Morgan Loudon and Burris, what they were looking for to fill the position.
Okay, thank you. Sorry, I've been too greedy here in my question asking. I apologize.
I noticed my time has expired, and if there are no further questions, we'll rest on our brief and ask the court to affirm the district court's judgment.
Thank you, Mr. Srinivasan. Mr. Ward, we'll give you 2 minutes for rebuttal.
Yes, Your Honor. Thank you. Yes, I want to direct my attention to the statement that was made by counsel for DHS regarding Mr. Taylor indicating that Mr. Taylor had 3 years of experience between 2011 and 2014 that may have been relevant to the bank card job. I just wanted to say that experience probably was not relevant in as much as Mr. Boyd, who had supervised Mr. Taylor and who worked at the adjoining position, also within the same department, and who was in charge of bank cards, would have known if Mr. Taylor had done bank card work, because that bank card work would have had to come through his particular department. So any indication that Mr. Taylor would have picked up 3 years of experience between 2011 and 2014 regarding bank card is not accurate. And also, one last issue, Your Honor, regarding internal controls. One of the issues in this case that was raised by the government was that my client did not have internal control. That's completely false. I indicated that in a deposition that she did have internal controls experience. And if you go back and look at the statements made in our statement of facts to which the government agreed to, it showed that she had plenty of internal control experience in addition to the bank card experience.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honors.
This honorable court is now adjourned until Friday, January 8th at 9:30 a.m.